Britain inherited a property rights system in Palestine that was fundamentally different from the European model. Unlike England at the time, where most farmers were tenants working large estates owned by aristocrats, the Palestinian peasantry held rights under the Ottoman Miri system that were the functional equivalent of private ownership. The state was the nominal owner of Miri land, but the state granted peasants an extensive set of legally defined rights called tasarruf. Those rights included exclusive rights to live on the land, build on it, farm it, and reap its benefits. Upon the holder's death, the tasarruf rights passed to their legal heirs, just like private property. Tasarruf rights could be sold to individuals or institutions, just like private property. Tasarruf rights could be used as loan collateral, just like private property. A holder could lease his land to tenant farmers, just like private property. Crucially, here's what makes tasarruf rights fundamentally different from a landlord-tenant lease. The state's nominal ownership of Miri land came with strict legal limits on the state itself. It couldn't revoke tasarruf rights as long as taxes were paid and cultivation continued. It couldn't sell the land out from under the holder. Any buyer had to acquire the rights directly from the current holder, not the state. While Miri generally governed rural lands, mulk, a system much closer to European-style private property, was more common for urban land. The main functional difference between mulk and Miri was that Miri required continuous cultivation. If Miri land was left fallow for several years without a valid excuse, the state could reclaim it. Mulk property had no such usage requirements. So, who owned the land in mandatory Palestine? Jewish land ownership is commonly cited at 6 to 7%, a figure that counts Miri land as private property, which makes perfect sense. To be consistent, Arab-held Miri land must be counted the same way. What happens when we apply the same rules to both? According to the British Village Statistics of 1945, Arabs held 48% of the land, Jews held 6%. The remaining 46% was state land, mainly in the Negev desert, but there's a catch. By 1946, only 20 to 25% of all land had been formally registered under the British system. Of the Arab land registered, about half was held by large landowners, while fellahin held the other half. To estimate unregistered holdings, British surveyors relied on tax rolls and village testimony. But with more than 1,300 Arab villages and limited staff, especially during the upheaval of the 1936-39 Arab Revolt and World War II, measuring the full extent of Arab land possession was impossible. Yet even using the conservative figures from the Village Statistics Report, one fact is beyond dispute. Palestinian Arabs legally possessed the vast majority of land in Palestine before 1948. Thanks for watching. Please hit the like and subscribe buttons if you would like to see more content like this.